Gomez. My question to you, what condition did we place on you before? We put a no driving affidavit on your prior case.
Yes, sir.
I'm now revoking the bond on that case, and I'm going to raise it up. I'm now finding this bond wholly insufficient, as well as you refuse to comply with bond conditions set with this court. And I'm finding that by clear and convincing evidence. As a result, I'm finding this bond wholly insufficient as well. We are now taking you into custody because of a felony warrant, but I'm now revoking the bond.
The charge sounded small, but the judge was looking at the pattern, not just the marijuana. A defendant already had court conditions. Then another case appears, another stop, another explanation. And suddenly the hearing is no longer about a cigar with weed inside. It becomes about trust, bond, and whether the court believes one more chance will mean anything. Slow, this is where the judge stops warning and starts acting.
Okay, who do we have here?
This is Christopher Gomez on page 9, Your Honor.
All right, good morning, Mr. Gomez.
Good morning, Judge.
All right. So with us, you were on bond for a felony less than a gram case from October. In December, you pick up a weed case, and now you've picked up another weed case. You are now charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 20th, 2024, the officer observed the defendant's vehicle, a silver BMW, bearing the wrong license plate. The officer conducted a search and learned the license plate was registered to a Hyundai four-door with the expired registration of December 2022. The traffic stop was conducted, and the officer observed the driver throw a brown object out of the driver's side window and land on the road. The officer made contact with the defendant, the driver, and sole occupant, and observed a strong odor of marijuana and a green leafy substance residue on the front of the defendant's shirt, known to be marijuana based on training and experience. The defendant stated he removed plates from his mother's motor vehicle due to not properly registering his motor vehicle. The officer walked back to where the defendant threw the brown bag and located a large cigar containing marijuana. The weight of the marijuana was 2.5 grams.
I'm going to find that there's probable cause to go forward with your case, Mr. Gomez. My question to you, what condition did we place on you before? We put a no driving affidavit on your prior case.
Yes, sir.
I'm now revoking the bond on that case, and I'm going to raise it up. I'm now finding this bond wholly insufficient, as well as you refuse to comply with bond conditions set with this court. And I'm finding that by clear and convincing evidence. As a result, I'm finding this bond wholly insufficient as well. We are now taking you into custody because of a felony warrant, but I'm now revoking the bond on your first case as well. Goes with you.
Street racing enters the courtroom with speed, risk, and a gun in the facts. Before this hearing ends, the judge has to decide who still gets to drive.
Both of you gentlemen are charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, gentlemen.
Would you like to start with, Judge?
I guess Lopez.
Lopez? Yes, Judge.
Alphabetically.
On December 22nd, officers conducted a traffic stop on the defendant's vehicle at the 17,000 block of Gulf Freeway. The officers were acting in an undercover capacity as they were conducting surveillance on a car group known to conduct illegal street races. The officer observed 3 motor vehicles begin to slow down, match speed, and pace. The 3 motor vehicles slowed down to approximately 50 miles per hour before accelerating to speeds in excess of 100 miles per hour in a competitive manner. The defendant was a driver and sole occupant of one of the motor vehicles. The defendant was in possession of a 19mm handgun, which is located on the floorboard of the driver's seat at the time of the stop, and the co-defendant, who was driving one of the other motor vehicles, was also taken into custody.
Who's the co-defendant in that?
The co-defendant is a Jabari McCall. Let me see if he's in our.
Is that
He was driving one of the other motor vehicles.
In his
Sure.
case, is in court 15, Your Honor.
that's in court 15? What is the cause number on that one?
Cause number is 254-4343.
So these need to go 15.
Correct. That one goes to 15. Right.
These will go to 15.
Well, Mr. Lopez, let's talk about Mr. Ruiz.
Yeah.
Okay. All right. So, Mr. Lopez, I am going to find that there's probable cause to go forward with the case. Does he have a Texas driver license?
Let me see, Judge. It's eligible, Your Honor.
Do you have liability insurance in your name?
Yes, sir.
I'm telling you now, if I find that you do this again, I will, number one, take your ability to drive away from you until this case is over with. And I'm going to tell you, living in a city as big as Houston without the ability to drive blows. It's awful. Trust me. If I find that this happens again, likewise, I will put you in jail and make your bond sky high. 610, 59, no place for racing. Do you understand?
Yes, sir.
Not only that, the Texas legislature has made it extremely easy for DAs across the country to take seized cars from individuals who participate in these types of acts. 2 weeks ago, we had someone here who had their $100,000 car seized by the district attorney's office for participating in this act. Do you understand?
Yes, sir.
All right, Mr. Ruiz.
On December 20th, 2024, the officer was part of a traffic crimes task force and was near the location where a large group was meeting at Alameda Mall in Harris County, Texas. The officer began following the racing group going southbound and observed the defendant and co-defendant's motor vehicles traveling in lanes 1 and 2 side by side, saw the two vehicles slow down to approximately 40 miles per hour, and then launch an acceleration at the same time in a competitive nature in order to outdistance each other at speeds of upwards of 110 to 120 miles per hour. A traffic stop was initiated and the officer made contact with the defendant.
Mr. Ruiz, I'm going to find that there's probable cause to go forward with your case as well. Tell me, does he have a co-defendant in this case as well?
Yes, Your Honor, and I'm pulling up the co-defendant's case.
It's in court 7.
Court 7, Your Honor.
Okay.
It should, that one should.
It's the cause number.
The cause number is 254-4176.
Okay, so this one stays here. Mr. Ruiz, at 120 miles an hour, I am now taking away your privilege to drive. You are not allowed to drive whatsoever. Do you understand?
Yes, Your Honor.
You will be signing an affidavit with me, promising me that you're not going to drive, and I don't give a rat's behind what your excuse is. I don't care if there's a burning building and 50 children need to be saving. You get into a car and drive. I can have a contempt hearing, and you can be facing an additional 6 months in jail and a $500 fine every time you get into a car and drive. Do you understand?
Yes, Your Honor.
Until I know that he absolutely appreciates the privilege, the awesome privilege it is to drive. You are not allowed to drive for any reason. Come back, show me some proactivity, show me the appreciation, and then if you come back in 2 weeks, it's just not enough time. But I want to see, something that shows me that you appreciate it. But for now, if I find that you drive, I'm going to light you up like a Christmas tree. Do you understand?
Your Honor.
Both of you have lawyers, so we will waive your appearances, but it is your responsibility to stay in touch with Mr. Clay, and he will tell you when you have to come back to court. If he comes back to me and tells me he can't get a hold of you because you're playing games, then I will revoke your bond. Neither of you will get a PR bond if you become a danger to my community, pick up new cases. Are you both United States citizens?
Yes, Your Honor.
Okay. All right, Mr. Clay, they go with you. Sir.
Judge, after we
Mr. Glover,
DW
you're charged with
refers
burglary of a
crash
motor
becomes
vehicle.
more
You're
than a
facing
crash.
up to a year in
The
jail
court hears
and a
about
$4,000
garages,
fine.
flight, a
We're going to
combative
do
arrest,
probable cause. You
and an
have the right
officer
to remain
left bleeding.
silent. Anything you say can or will be used against you. You have the right to have an attorney present. You're on bond for a burglar of a motor vehicle, and now you've picked up a new case.
That case,
Stop. You were on bond for a burglar of a motor vehicle, and now you've picked up an assault of a family member. You're now facing a year on that one as well. We're going to do probable cause on both of your cases. You have the right to remain silent. Anything you say can or will be used against you.
Yes, Judge. On the burglary, the officers were dispatched to a burglary call at a residence in Harris County, Texas. The complainant told the officers that items were missing from his work truck, which was parked in front of his house. The complainant had cameras inside and around the truck, which captured the defendant's face. The officers received a tip from Grizzy identifying the defendant and were able to confirm the defendant's identity by viewing the captured surveillance.
Bless Gizzies. Hood news. You guys familiar with the hood news? It's good stuff. So say it again. Nothing.
For the burglary?
No, the assault.
So on the assault case, the complainant and the defendant are in a dating relationship. And on December 20th, 2024, the officers were on patrol at Katy Freeway Service Road and observed the defendant and the complainant. The officer observed the defendant dragging the complainant by her hair towards the sidewalk. After the defendant saw the officer, he let go of the complainant and both began to walk towards the patrol vehicle. The officer detained the defendant and spoke with the complainant. The complainant stated she and the defendant were in an argument and the defendant was following her to get inside his car because she was walking in the road. The complainant did not have visible injuries, but stated she bit her lip and caused it to bleed. The complainant stated she did not feel pain from having her hair pulled. The complainant stated she felt 3 out of 10 pain.
Mr. Glover, I'm going to find that there's probable cause to go forward on your assault case. Tell me about the BMV, please.
On the BMV? So that was the one where they were dispatched to a residence in regard to a BMV call, and the complainant had cameras inside and around the truck, which captured the defendant's face, and he told the officers that items were missing from his work truck, which was parked in front of his house.
So they got him on camera with the home camera.
Yes, Judge.
Was he on bond for our burglary case and then picked up the new case? Do you guys?
Yes, Judge, it seems like our
Did we do conditions and everything?
It looks like there were conditions on the 15th of December and the new case was on the 20th of December.
So we had him, we put conditions on him.
Looks like there were conditions.
Looks like that's a nice regular judge.
Judge, he may have been arraigned by the magistrate. I don't know if he ever came before.
Mr. Glover, let me make something extremely clear to you. I'm going to do everything in my power to protect my city at all costs. I don't care who you are, what color you are. If you're a small farm animal, I'm going to protect my city at all costs. You endanger my city, I'm going to light you up so fast you're going to have teeth falling out. Do you understand? You were not to have contact with the complainant in this case at all whatsoever. And I'm now sending you for a drug test because I want to know what, if anything, is in your system, and you're to come right back. If you fail to go take the drug test, if you fail to come back, I will revoke both of your bonds and make them sky high. As it stands now, you were given 2 PR bonds in these cases. You pick up a third case. Holy moly. Do you catch my drift?
Yes, sir.
Francis, let's send him right now. You are to come right back.
A parking lot takeover turns into a gun case. The allegation is not just possession, it is a firearm fired into the air in public.
Working with Ms. Turner.
I'm covering for her. I drew the short straw this week. Everybody
That's
else is
okay.
gone.
Not a problem. We're happy to have you.
Thank you.
Mr. Vasquez, you were charged with discharging a firearm in a metropolitan area. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 20th, 2024, the officers were conducting surveillance on several vehicles engaged in a parking lot takeover while in an undercover capacity. The officers observed the defendant, who was the passenger in a vehicle that was driving alongside them, roll down the window, stick his hand out with a handgun, and discharge it into the air. The officers advised that they saw the defendant discharge the weapon a total of 6 times. After detaining the defendant, the officers located the firearm under the passenger seat where he was sitting.
Mr. Vasquez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to be in possession of any weapons, not to use any weapons, not to fire any weapons. Do you understand? If I find that you do, I'm going to put you in jail. You will not get any more PR bonds. What goes up must come down. What happens if it lands on someone's head and kills them? Who gets charged with murder? Think about it. Think before you act. Think before you speak. Because you dig yourself into a big hole, your ass ain't getting out. Do you understand? If I find you with a weapon or you pick up a new case, all bets off. Do you mind filing those conditions, please? Mr. Vasquez, you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with counsel. If they tell me that you play games, that you're not responding to phone calls or text messages, I will issue a warrant for your arrest. You pick up a new case or become a danger to my community, I'm going to light you up. Do you understand? Okay, guys. I'm going to have you sign a reset with Ramona. After that, I'm going to have you take a seat in the jury box. I will get your bond conditions. We'll have you sign it. After that, you'll be free to go. Thank you, sir.
A car is found stopped on metro rail tracks, but the DW fuss facts are only part of the problem, because another serious case is already in the background.
Mr. Jefferson, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 22nd, 2024, at approximately 3:30 a.m., the officers were dispatched to the 800 block on Louisiana Street in regard to a motor vehicle parked on the Metro light rail tracks. Upon arrival, the officer observed the defendant's vehicle on the tracks, with the defendant asleep behind the wheel of the vehicle.
On the tracks?
Yes, Judge.
Ugh.
The vehicle was turned on and in the park position. Upon contact with the defendant, the officer observed slurred speech, glossy eyes, and an odor of an alcoholic beverage. Standard field sobriety tests were administered. 0 out of 4 on the one-leg stand, 0 out of 8 on the walk and turn. The defendant did not finish the test, and HGN was 6 out of 6. The DIC was read, and the defendant consented to breath. The results were .091 and .09.
He's on bond for an aggravated robbery.
Yes, Judge, that is correct. Out of the 174.
All right, can you tell me if he has any prior DWIs, please? And
There's no
if
prior
he has a license?
and his license is eligible.
Mr. Jefferson, I'm now placing a restriction on you. I'm giving you a curfew of 9 p.m. to 6 a.m. And I'm going to put an ankle monitor on you so I know where you are at all times. You're on bond for a very serious case. Now you picked up a new case. It's very possible they revoke your bond on the felony case. Do you understand? I don't want you out in the middle of the night. If I find that you violate these conditions, I'm going to put you in custody. I'm going to protect my county at all cost. Do you understand? If I find that you're consuming alcohol or illegal drugs, likewise, your bond will be revoked. You will go into custody. And I'm telling you now, if I find that you're a public danger, I'm going to make it sky high. You missed court yesterday. So I don't want you to say anything. You have the right to remain silent. Exercise that right. The only thing I'm telling you now is I will give you a pass because you missed yesterday. If you ever miss court again, this is not going to happen. Do you understand? I'm going to reinstate the bond now. Francis, do you need the cause number for this case?
I have it.
You have it? Okay. No alcohol, no drugs, no weapons. And he now has a GPS monitor with a curfew of 9 p.m. to 6 a.m. You must charge this ankle monitor on a daily basis for at least an hour. If the battery goes dead, so does the bond. Do you understand? You can waive all the fees as well. All right, I'd like him to get it today as well. Francis, please. All right, Mr. Jefferson, what we're going to have you do is I'm going to have you go to Ramona, sign a reset, and then you're going to get with Francis for your bond conditions. You're already in enough hot water as it is. All you're doing is you're adding fuel to the fire, man. Really, don't say anything. I'm just telling you how to behave in this life. There's certain ways to act, certain ways not to. Do you understand? Come on.
A crash does not end at the first. The allegation says the driver kept going for miles before losing control again.
Information, which is leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge.
Okay.
On December 20th, 2024, the officer was dispatched to a major accident at 6623 Gulf Freeway in Harris County, Texas. The officer learned there were two separate accidents, first at 9301 Gulf Freeway and second at 6623 Gulf Freeway. The complainant stated he was driving his motor vehicle, was stopped at a red light, and the defendant failed to control speed before rear-ending the complainant's motor vehicle. The complainant heard the defendant's tires screeching, and the defendant drove off at a high rate of speed. The complainant followed and chased the defendant's vehicle as the defendant entered and exited the freeway, attempting to get away. The complainant followed the defendant approximately 5 miles, and the defendant lost control and crashed into a home. The damage to the complainant's vehicle was $2,000.
What time of day or night was this? Was middle of the night? Any kind of alcohol?
This was appears at midnight, and there's no allegations of alcohol.
It was
License, stop.
I apologize. It was at lunchtime, 12:29 p.m.
PM. Okay. Any a license?
License, Your Honor. It appears the Florida driver's license that's valid.
Have liability insurance in your name, car insurance.
I was driving my mom's car.
I don't care if you were driving Santa's sleigh,
I don't.
then you're not allowed to drive. I'm making that a condition of your bond. Until you have liability insurance in your name, do not drive. Do you understand? I'm making it a condition of your bond. Until you show us that you have liability insurance, then I'll take this off. But until that point, don't drive.
A DWI stop starts with a stranded vehicle. Then the court hears about an open container, breath results, and a warning that could change bond completely.
Driving while intoxicated, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. And ma'am, Ms. Silva, you're charged with prostitution. You're facing up to 6 months in jail and or a $2,000 fine. And we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. If you cannot afford a lawyer will be appointed to represent you, ma'am. Okay, let's start with Suarez.
Yes, Judge. On December 20th, 2024, at approximately 4:38 a.m., the officer was dispatched to a stranded vehicle at the 11700 block of South Sam Houston Tollway. Upon arrival, the officer observed the defendant to be asleep behind the wheel of the car with gear shift in drive position and foot on the brake. There was an open container half filled with an alcoholic beverage, and the officer observed the defendant with glassy eyes and unsteady balance. Standard field sobriety tests were conducted, 6 out of 6 on the HGN, 2 out of 8 on the walk and turn, and 3 out of 4 on the one-leg stand. The DIC was read and the defendant consented to breath. The results were 0.142 and 0.145.
Mr. Suarez, I'm going to find that there's probable cause to go forward with the case. I would hope that you would recognize it's elementary that you're not supposed to have alcohol in the car while you are driving. It is a minimum of 5 days in jail to any sentence that you get when they allege that you have alcohol in the car. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail, immigration will find you. They will put a detainer on you. Do you understand? I'm putting conditions on your bond. You violate these conditions, I will put you in jail so fast your head will be spinning 100 miles an hour. Do not consume alcohol, do not use illegal drugs, and do not drive. Do you understand? If you violate these conditions, I will put you in jail and I'm going to make your bond high. The reason you got out of jail quick because we gave you a PR bond. No more if you become a danger to my community. You understand? I'm going to have you come up here, swear to us that you're not going to drive. I'm going to get you to Ramona. We are going to give you a reset to give you time to hire a lawyer. After that, you will get with Francis for your bond conditions. Don't consume alcohol, and above all else, do not drive. Do you understand? Heed this warning. You will not get another.
A DWF crash becomes more than a crash. The court hears about garages, flight, a combative arrest, and an officer left bleeding.
Unless you're charged with driving while intoxicated, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 21st, 2024, at approximately 1:30 a.m., the officers were dispatched in reference to a one-vehicle collision. Upon arrival, the officer observed the defendant's motor vehicle with major rear end damage and debris all over the vehicle from having collided into an apartment complex. Upon contact with the defendant, both officers and a witness observed the defendant with slurred speech, strong odor of an alcoholic beverage, and red, bloodshot eyes. The officer also observed the defendant to be disoriented and stumbling. While on scene, the defendant became physically combative, belligerent, and aggressive with the officers and attempted to kick the passenger door and headbutt the officer. During the altercation, the defendant grabbed the officer's right forearm and scratched him, breaking skin and causing him to bleed and feel pain. The officers made contact with the defendant's front passenger, his wife, who advised they were coming from a party where the defendant drank. And as the defendant was reversing his vehicle, he crashed into two garages and then fled the scene to continue looking for parking. The officers did not request standard field sobriety tests since the defendant was being combative and for officer safety. A blood warrant was signed and executed.
You look to see if he has any prior DWIs, please. Mr. Thomas, and then license.
Eligible, Your Honor.
Mr. Thomas, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using illegal drugs or alcohol, I'll put you in jail. No more PR bonds for you. Do you understand?
Yes, sir.
If you don't have Texas, or if you don't have liability insurance in your name, then you're also not allowed to drive, and that's a bond condition of yours as well. Do you understand?
Sir.
You have a lawyer. They will take care of you. It's your responsibility to stay in touch with them. If they tell me they can't get a hold of you, likewise, I will issue a warrant for your arrest. Don't become a danger to my son, to my city. Otherwise, I only have one place for you. Do you understand? All right. I'll have you sign a reset with Ramona. You'll get with Francis for your bond conditions, and then you guys are free to go.
Thank you very much, Your Honor.
Please.
Yes, sir.
A cold beer in the cup holder changes the tone. The judge is not just asking whether there was a DWI, he is deciding whether this defendant should drive at all.
Mr. Secretary, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
On December 21st, 2024, officers were dispatched to a firefighter call for a person down at approximately 1:24 a.m. Houston firefighter advised the officer that he observed the defendant to be asleep behind the wheel of his vehicle, despite attempts to wake the defendant with their horn. When the officer arrived on scene, he observed the defendant inside his vehicle while the vehicle was on and in park at the 4300 block of Bylock Road, and the defendant admitted to drinking about 8 drinks and stated he had just left the sports bar. The officer observed the defendant to have glassy eyes, poor balance, and odor of an alcoholic beverage. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 4 out of 8, one leg stand 2 out of 4. While inventory of the vehicle, the officer located one open 12-ounce Coors Light can in the center cup holder, which was 1/4 full and cold.
Drinking while driving.
Yes, Judge. And the defendant, and the DIC was red, and the defendant consented to breath. The results were .087 and .08.
Mr. Secretary, I'm going to find that there's probable cause to go forward with your case. I'm now taking away your privilege to drive. You are not allowed to drive whatever for any reason. Do you understand?
Yes, sir.
You will be signing an affidavit with me today, promising me you're not going to drive, and I don't care what is going on in your life. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. I don't care what your reason is. There's no justification you can give for getting in a car and driving. Do you understand?
Yes, sir.
This is a court order. This is an affidavit and promise you're making to me now that you're not going to drive. Heed this warning. I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're using, likewise, you will go to jail. No more PR bonds. We are going to reset your case to give you.
The closer begins with a threat allegation. A shotgun, a cartel reference, and one complainant's fear lead the judge to draw a hard line.
Sir, you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Please.
On May 14, 2024, the officer responded to a resident in Harris County, Texas, in reference to a terroristic threat. The officer made contact with the complainant, who stated the defendant, the wife's uncle, threatened to return to the residence with a shotgun to shoot him, and that he would shove the complainant's pistol up the complainant's ass, and that he would return with a cartel so they could take care of it. The complainant stated he believed the threats to be imminent and he feared for his life.
How did you get appointed so early?
He made a request for appointing counsel when he was in jail in Montgomery County.
Okay, so he was,
And y'all appointed me, and then he got transferred here and
got it.
received his bond conditions and general order bond last week.
All right, Mr. Rod, I'm going to find that there's probable cause to go forward with the case. I'm putting 2 conditions on your bond now. Not to be in possession of any weapons and not to have contact with the complaining witness in this case.
Yes, sir.
How long did you spend in jail, sir?
I was there the 14th all the way up till the time they transferred me here, and I believe I was released on the 20th.
How pleasant was your stay in custody?
It was not pleasant at all, Your Honor.
Then all I'm asking you to do are 2 things, and as long as you can do that, you and I will be best friends. Otherwise, it's not going to go well. I don't want to have to put you in, so just, that's all,
I
okay?
understand, Your Honor.
Got a great lawyer, Carl. He'll take care of you. Just make sure you stay in contact with him and all will go well.
Yes, sir.
If he tells me he can't get a hold of you because you're playing games, you're off the radar, I will issue a warrant for your arrest, okay? So just stay in contact, follow the conditions, and that's it,
Yes, sir.
okay? All right.
Thank you, Your Honor.
We need him to sign conditions here, and then after that, he's free to go.
Okay.
Okay? All right.
Thank you.
He signed conditions already. I think they're pretty much the same as what you just said. And he also has a MOAB in addition to the bond conditions, which have no contact with the defendant, no weapons.
They were signed by the magistrate on the 20th, Judge.
I don't know how they put the MOAB on.
Got a copy of the MOAB.
And it's not a family member. There's no allegation of a family member, so they can't put the MOAB on.
Yeah. It's still,
You know?
bond condition covered anyway.
But just so you guys know, I mean, there's no allegation of a family member in the information
Okay.
or in the 2B.
I believe it's the,
It's
it's
the
the,
wife's uncle.
right, the
Yeah.
complainant's wife's uncle.
Yeah.
But we can look at the.
It says, it only says, did then and there unlawfully threaten to commit an offense involving violence as opposed to like family violence or upon a family member. And so that's why just no contact and you'll be fine. Okay.
Not a problem.
Nobody-
All right.
nobody calling for judgment.
I'm okay. I'm okay with it. Yeah, I see it. All
Thank you,
right.
Judge.
We got you.
All right.
Thanks.
Thank you.
Take care, sir.
You want to leave the warrant?
No.
This session shows how fast bond can turn from freedom into custody. In the marijuana case, the judge focused less on the small amount and more on the pattern of ignoring court conditions. In the street racing and DWI hearings, the same theme repeated. Driving is a privilege, and public safety can override convenience. And in the firearm case, one warning carried the whole point. What goes up must come down. Courtrooms do not just punish what happened. They try to stop what could happen next.